Okay, so here we are moving into Unit 3, Basics of Law and Value of Evidence. So as a reminder, I'm the science expert, not necessarily the legal expert. So if anybody out there catches me saying something that's not quite right or downright incorrect, please don't hesitate to shoot me an email, let me know about it, and I'll be sure to correct it. Again, I'm here to make sure the science is good, and I try my best to keep the law all correct, but if you do notice anything that's misleading, please don't hesitate to let me know. We've already discussed that forensic science is the application of science to law, so we look here now at forensic science and how it's used by law enforcement and the courts to resolve both civil and criminal issues. We tend to focus on the criminal issues because they tend to be the ones that are of greater interest to the public, but don't forget civil matters also are in the purview of forensic science, and forensic evidence is important in those matters as well. The value of evidence found is examined, interpreted, and evaluated so that conclusions can be made. Again, it's not typically a single piece of evidence that turns a case, but oftentimes it's multiple pieces of evidence that substantiate one another, corroborate one another, and so on and so forth. So in order to make sure that all of this evidence is of the highest quality and meets the highest standards, we have our ethics, right? The ethical standards so that evidence is not corrupted, so that we can believe the evidence as presented. If we go back to our good friend Edmund Locard, we have Locard's principle that tells us the physical evidence cannot be wrong, only its interpretation. So we need to make sure that that physical evidence was collected correctly and analyzed properly, and that we can trust the conclusions made from that physical evidence. Okay, so as the application of science to law, forensic science is an applied science within a legal setting. So we use physical evidence, right? Evidence that we can touch and analyze with the senses and with instrumentation that extends those senses to prove or disprove facts in question in a court of law. Forensic scientists have been trained in one of the sciences, like biology, chemistry, geology, and physics, or multiple sciences through a program in forensic science, for instance, so that they have a background that's, again, sufficient for them to be able to analyze and interpret results for analyses of physical evidence. So we should be able to trust our forensic scientists. They should be individuals who are there to get at the truth of the matter, not necessarily to support the prosecution or the defense, but rather to support the facts as they see them based on the evidence and its analysis. We'll see, unfortunately, as we move on in the course, that there are a number of times that that didn't happen, but still, that's a relatively minor number of forensic scientists who have not upheld the ethical standards. For the most part, forensic scientists are very law-abiding and ethical individuals. It's just a few bad apples that have given forensics a bad name in the past. Hopefully we won't have much more of that in the future. Before we move on, let's just take a moment to make a distinction between ethics and morals. Again, it's a science class, and we tend to focus on the scientific method and scientific observation and analysis, but since we're in a unit on law and the value of evidence, let's just make sure that we have a distinction in our mind between ethics and morals. So ethics are the standards of conduct that are agreed upon by a society, whereas the morals are our own principles. Morals tend to change with societies. So something that was deemed moral back in ancient Rome is oftentimes deemed immoral in modern American society. But ethics should be really fundamental and based on, core ideas like respect for life and things like that. All of these things help to aid in problem solving, and again, since the scientists are the problem solver, it's important that they uphold the ethics of their profession and the morals of the society in question. All right, so this is a science class, not a criminal justice class, but it is important that we have at least a working understanding of what criminal justice entails. So criminal justice concerns the fair and equitable treatment of all individuals under the laws agreed upon by a society. One of the core principles of criminal justice is that there's fairness, equality, and impartiality, right? And that sounds a lot like science too, so some overlap there among criminal justice and the natural sciences. And then finally, where criminal justice departs is it's used to fairly judge crimes and punish individuals, right? So it's concerned with the actual penalty for violating the law. And in this case, it could be, as we said before, a criminal or a civil matter. But the criminal justice system is responsible for determining whether or not to initiate proceedings and what the outcome would be if a person were deemed to have violated the law in one of those types of matters. Now, the criminal justice enterprise is a large enterprise, and it involves a lot of different individuals. So probably the more well-known would be the law enforcement officers themselves, but you've also got politicians who, again, depending on what particular branch of government they serve, could be responsible for making laws. You have the legal institutions themselves, the courts, of course, where the laws would be tested. All these have to work together with the society to address issues. If the society is, in a situation where we're dealing with a matter that's a major societal problem, then we need to make sure that those laws and the penalties for violating those laws are sufficient to try to tackle that problem and make sure that it's not something that is overlooked or under prosecuted so that it becomes an even larger issue. Now, here in the United States, we are very proud that we tend to have a legal system that follows natural law. So natural law regulates behaviors of people based on universal traits and common experiences. And when we were first founded, these were fairly novel ideas to have things like human rights of life, liberty, and freedom. When we were dealing with monarchies where the king or queen was in charge and above the law, this was a novel idea to say that every citizen had these basic human rights. And of course, now we've got a distinction to make when we talk about common law, civil law, religious law. We'll get into that a little later on. But again, natural law derives from these universal ideas, and that has largely guided our criminal justice system in the United States since our founding. Okay, so a little earlier I made mention of the few times we've had some people bend the rules and maybe violate the ethics standards that we uphold in science. And they're dealt with harshly, but again, those are relatively few and far between, but when they do happen, they tend to be big news. Why is it so important that we have ethics in science? Well, because the scientists control the variables in an experiment, it's possible to manipulate results and achieve a desired outcome. So this is obviously not what we should be doing, but it is possible. Likewise, one of the more recent scandals in forensic science, when a person is charged with having an illicit substance, an illegal drug, let's say, they have the right to a confirmatory test. And there was a chemist in Massachusetts who decided that since the confirmatory tests almost always came back positive, she was just going to sign off as though she had done the tests and that they came back positive. And once it was found out, that resulted in the need to retry all that evidence at a cost of millions of dollars to the state of Massachusetts. So again, it took a while, and she got away with it for quite a while. Her colleagues would complain, and the supervisor would just say, well, you're jealous, you're not as efficient in your chemistry as she is. And then finally they complained to the right person, and she was investigated, and it was found that she was making these ethical violations. So we don't expect that to happen, but unfortunately it has happened more than just a few times in forensic science. So let's say that we're doing the right thing and that we are controlling our experiment in the right way. Well, then we would have results that could be replicated. And again, if we're talking about pure science that's been published after the publication, there are other scientists who would likely test that same methodology and make sure that they achieve that same result. So that's one way that we check ourselves within the scientific community. So ethics are used to combat the unethical scientists, and we're very harsh to scientists, whether it's forensics or pure chemists, pure biologists. Once someone breaches that ethical line, it doesn't matter if they've done anything illegal or not. If they've done something unethical in the sciences, they're pretty much ostracized from the scientific community. And so that's the way that we try to keep people from taking that easy way out. It still happens more than it should, but again, not as much as it would, I'm sure, if we didn't have such harsh penalties to extradite someone from the community. So it's really necessary to have these high ethical standards in science in general and forensic science in particular, because it allows for that validity and reliability that we need from science. We like to think of science as objective, but it's not. It's done by humans. We're subjective, and some of us are not terribly ethical people. So hopefully the idea that you could be found out is enough of a deterrent, but obviously, at least in the case of the woman in Massachusetts, it wasn't enough, and she got away with it for far too long. All right, so back in Unit 2, we talked about some forensic careers, and so crime scene investigators would be one type of forensic career. They're specially trained in ways to document and preserve the scene. They have knowledge of how to correctly preserve, collect, and document evidence according to procedures. And they would also document the chain of custody so that we know who has handled that physical evidence from the crime scene to the forensic laboratory. And all of this is necessary to minimize the possibility of contamination and mistakes. Now, one of the drawbacks is in a small town, you're not likely to have full-time dedicated crime scene investigators. So you're relying on local police who, again, receive periodic training usually in how to collect evidence. They have the little FBI flip book, the handbook of evidence collection standards available to them. But it's good that they have frequent updates, because these sorts of documentation and preservation matters do change. There's slight edits to procedures and things like that. So it's very important for local law enforcement to know, because they don't know when they're going to be required to do this sort of thing that in a large city you'd have a crime scene investigator to do. So again, whether it's a regular police officer or a specialized crime scene investigator, we do want to make sure that the evidence is documented, collected, and preserved correctly, so that we can trust the analysis that's finally done on the physical evidence, that it hasn't been contaminated before it's been analyzed. Now, because forensic science is an application of science to law, we do have to follow the scientific method. We reviewed that pretty extensively back in Unit 1. But again, just to refresh our memories so that we keep that in mind as we continue this discussion, first we want to observe a problem or questioned evidence. And in the case of forensic science, we said things are a little different because your problem is handed to you by the legal matter under question. So you're there with a result that you need to go back and try to figure out what happened to get there. So the way you do that is the same as with any scientific method approach. You'd collect objective data, consider a hypothesis or possible solution, or in this case, some potential ways that things could have happened. That, if let's say in a violent crime, how the victim was injured. Examine, test, and analyze that evidence, again, as objectively as possible, and determine the significance of the evidence. There's likely to be lots of different pieces of physical evidence that would be examined with respect to a single crime, and so it's important that you determine the significance of each piece and how they all fit in together, so that you can finally do the last step here and formulate a theory as to what happened, and maybe identify the suspects that make sense for that theory, and maybe exonerate those who really couldn't have participated in what you've theorized based on the evidence. So it's the same scientific method that all scientists use, but it's a little tailored to the forensic setting, where you sort of are given the problem of figure out what happened based on what we have, and do the best to formulate a theory that identifies the person responsible and exonerates any suspects who are not responsible. Back in Unit 2, we also identified some key individuals in the history of forensics, and one of those was Hans Gross, and he's the one who coined the term criminalistics. So criminalistics is the scientific examination of physical evidence for legal purposes. So again, before his treatise there, Criminal Investigation, he was one of the proponents for this very scientific approach. He wasn't the only one, certainly, but he was one that helped promote that and got the community behind it. He was an Austrian legal expert and law professor, and he was able to get the rest of Europe and the rest of the world really behind his ideas of a very scientific and objective approach to physical evidence. So we have him to thank for the term criminalistics. Now, criminology sounds almost the same, but it's slightly different. So criminalistics was that application of science to the collection of physical evidence. Criminology also includes the psychological angle, and that can be tricky, right? I'm a physical scientist, a chemist by training. I'm certainly no psychologist, so the psychological angle is not my area of expertise, but certainly it's important in studying the crime scene for the motive, traits, and behavior that will help interpret the evidence as it relates to the suspects, right? You're likely to generate at least a few suspects, and so knowing a little bit about the psychology involved in the perpetration of that crime, then you're likely to be able to differentiate between suspects if the physical evidence itself doesn't identify which of them is or is not possibly guilty. Then certainly the psychological motivations would be possibly one way to distinguish between multiple suspects and see who's the most likely one, who has the most motive, or whose behavior would be most compatible with the particular crime that was observed. Here in the United States, we have a very rich history in our criminal justice system, and it goes all the way back to the U.S. Constitution. As I mentioned, we were a country that was really founded on ideas of natural law and things that derived from that, right from the Constitution on, were quite progressive ideas at the time. So we were, a nation that had broken off from our colonial parent that was a monarchy, and established this very lofty idea of having individual citizens have their rights and have those rights derived from natural law as opposed to whatever the king or queen decided. So we've got, in addition to the Constitution, we have the Bill of Rights that was a supplement to it that spelled those individual liberties out a little better. Then we have statutory law. Common law or case law is more of a tradition, whereas statutory law is more written law. And then civil law, as we mentioned, is between citizens, private citizens. Criminal law, when it involves infringement on individuals' safety or things that would be covered by that Bill of Rights, we tend to look at those as criminal matters. Equity law, really trying to make sure that things are fair. Administrative law, see that governmental policies and laws are administered correctly. So we'll take a moment to look at each of these in turn, but that was just a brief overview of the different laws pertaining to our very rich criminal justice system history. So our U.S. Constitution has been in existence for over 200 years, and it's really withstood the test of time because the fundamental laws and principles by which our land is governed are things that the Founding Fathers established and that most of us can support still today because they're really fundamental to, again, natural law, the idea of humans having certain inalienable rights, and that was a progressive idea at the time, but now we've certainly come to expect that from democracies around the world. The Constitution is what made the separation of powers, right? 3 co-equal branches of government, and each a check against the other. So I think that's a nice way to keep things from going back to tyranny, the type of tyranny that we tried to separate ourselves from and successfully did under King George. Now we were in a position to make sure that never happened again, and the separation of powers has done that very well for over 200 years. The Constitution also mentions some of the rights and responsibilities of state governments, right, where this U.S. Country of states that are united, and so it's important to know what the states have to do and what the federal government is in charge of. So it goes on to spell out that state and federal government relationship. And finally, the last article, Article 7, talks about the procedure of elections, and so that's what was used after the U.S. Constitution was ratified. Then those procedures of elections were used for elections from that moment on. So a fundamental document that certainly identifies the core values of the country, but again, it's not alone. We'll talk next about the Bill of Rights and how that helped to spell out individual rights and responsibilities. Okay, so the Bill of Rights, it's a supplement to the Constitution, doesn't replace it. The Constitution is important. The Bill of Rights is important. The Bill of Rights is a supplement to that fundamental document, and it lists the most important rights of a citizen. So in particular, the Bill of Rights, which is subject to amendment and has been amended over time, but it's what allows us to have, at least in law, the right to freedom of religion, freedom of speech, the right to keep and bear arms, the right of a free press, the right to assemble freely without persecution, the freedom from unreasonable search and seizure. And again, the key word there is unreasonable. It doesn't mean that you can never be searched and your property can never be seized, but it should not be done without a warrant. It shouldn't be done in an unreasonable fashion. The security and personal effects, we shouldn't worry about our things being taken without cause, and the freedom from warrants issued without probable cause. So there we have another phrase that we'll talk about in the course, probable cause. Again, you've got to be able to convince a judge that it's worth issuing a warrant in order to have search and seizure occur. So these were not rights that the colonists had, and that's one reason that they split from their colonial parent, was because they didn't like that they didn't have these guarantees. So it was important to let the new country know that as citizens of the United States, you have these rights and your rights are protected by the Bill of Rights. It also guarantees a speedy and public trial with an impartial jury. We mentioned that when we talked about the different crime labs, and that we need multiple crime labs in New York, for instance, to allow for the analysis of drug evidence in a way that allows for a speedy trial. It still takes a while, but if you were to close one or more facilities, it would take much longer, and it would possibly infringe upon that Sixth Amendment. Finally, it prohibits double jeopardy, so you can't be tried twice for the same offense, and that's an important legal precedent, so that you could just be in court forever if they had not specifically prohibited double jeopardy. So lots of important rights spelled out in the Bill of Rights that weren't necessarily in the Constitution itself, although they're all in line with the philosophy of the Constitution. So the U.S. Constitution and the Bill of Rights are sort of the federal level documents that really spell out what this country believes in terms of its legal criminal justice system sort of philosophy. Statutory law, this is the written law set down by a legislature or other official governing body. Again, a state legislature could have be the source of these statutory laws, and they can be different from state to state, right? There's usually not huge variations, but states can have different interpretations and slightly different laws from one another. So the states have their own legislatures, and they're able to make their own laws, and that's again part of our interesting dynamic as a federal government of individual states that have united to form these United States. So it's important that the states have these rights because otherwise, the federal government would have all the power, and that would probably not be as enjoyable as having states with a fair deal of leeway in making their own laws. Now, common law or case law, this is the body of law developed from judicial decisions based on custom and precedent. So it's not necessarily codified, written down to the letter like statutory law. This is really more just in line with the customs, with the precedent. You know, it's a way to practice law that has sort of been deemed acceptable because it's in line with other decisions. It doesn't necessarily have its own specific written law, but this law is permissible because it's in line with custom and precedent. So now we'll go ahead and distinguish between civil and criminal law. So civil law, body of law of a state or nation regarding ordinary private matters. So these are private disputes among citizens. These are governed by civil law. And civil law, as I mentioned, can have forensic science involved, although it's not necessary, and it's certainly not typically as exciting as the sort of forensic applications we see in criminal law, but it is another area where forensics is important and can be a useful tool for one or both parties in a civil matter. Criminal law tends to deal with more severe matters, not just simple disagreements among citizens, but something that really is a more threatening type of menacing behavior. So it's the body of law that governs over criminal acts. It regulates social conduct by, again, attaching penalties to behaviors that are deemed unacceptable. So it deals with anything that is threatening, harmful, or endangers property, health, safety, and moral welfare of a citizen. So that's the big distinction between private dispute among citizens and civil law. Criminal law, again, deals with that potential for harm is really what we're looking at. And it includes punishment for violating those laws. A civil matter may deal with monetary fines or something like that, a monetary payment. But here the punishment could involve money. It could be a fine, or it could involve jail time, as it often does. Okay, equity law, there we have justice, right? The embodiment of justice, and she's blindfolded because justice should be blind, right? So equity law says that there should be fairness and impartiality in the matters of common law. So whether you're rich or poor, person of color or not, then you should be equal in the eyes of the law. And unfortunately, in the United States, we've had some instances where that didn't appear to be the case, but hopefully, by and large, we uphold that standard because that's certainly part of our core beliefs in our Constitution and our Bill of Rights. So equity law, the equitable, the fair and impartial application of law. And finally, we'll just briefly discuss administrative law. So administrative law governs the activities of the administrative agencies of the government. So, this would be things like, let's say, the U.S. Environmental Protection Agency, the Clean Air Act of 1970. If there's, states violating things from that law, then we'd be looking at sort of administrative law channels to determine what sort of penalty or punishment, or how to force compliance, those sorts of things. So that's what we mean by administrative agencies of the government. They're making sure that those laws for agencies are followed, and if they're not being followed, then how can the agencies force some sort of cooperation and make sure that the laws are being followed, that there's some compliance at the level that there needs to be for the law to remain in effect. All right, so turning ourselves back to physical evidence, which is what the forensic scientist is charged with analyzing, we have to look at the value of the evidence. Does it prove something towards the case? What is its probative value? If it doesn't prove something toward the case, then it's not really important to the proceeding, right? It's probably going to be deemed inadmissible, but hopefully it's been collected, analyzed, documented properly, and it is of probative value so that it would be presented in the legal proceedings. That's what we're hoping for, and that's why we go to extremes, to make sure that there's no question that the evidence was correctly handled. We see in our little graphic there an evidence form to identify who's collected the evidence, where it's been stored, all the things that you would be able to present then in the legal matter to show that it is valuable evidence, it has been correctly stored, correctly analyzed, and that it does have value in proving something relevant to the case. Okay, so let's turn to the different types of evidence. If we look at our graphic here for our evidence types, we have direct evidence and indirect evidence. So direct evidence will prove point in fact without interpretation of circumstances. Now again, that sounds more like the scientific sort of things, but what we'll find is actually we're often looking at indirect evidence. In forensics, we're almost exclusively analyzing indirect evidence because that's the circumstantial evidence that requires interpretation to prove the point in fact. And so we'll see physical evidence, it's found at a scene or it's found on a suspect, but it's really the interpretation of the analyses and the results that allow for us to try to link it to the particular case at hand. So moving along on direct evidence, we have evidence that establishes a fact. So it's eyewitness or victim testimony. It's the confession of a suspect. It's something found on the person, an audio or video recording of the act or crime. Again, these would be types of direct evidence. Unfortunately, even these can often be found to be invalid, right? Eyewitnesses make mistakes. People confess under duress, and it's not a valid confession. Those sorts of things. So just because it's direct evidence, unfortunately, doesn't mean it's really this evidence that cannot be altered, that cannot be changed, that we trust absolutely, because there's unfortunately no absolutes with the direct evidence. So we already mentioned a little bit about this, but there are some problems with direct evidence. So first of all, as mentioned, eyewitnesses may not be reliable. They may add their own perspective, and that can make direct evidence that should be reliable and trustworthy sometimes less than trustworthy. Likewise, we've got our right to a speedy trial, but that can still involve years before the legal matter actually moves to trial. So the passing of time may result in faulty testimony from the witnesses, from the suspect, even from the officers. And that's one reason why you want to make sure that we have very, very detailed documentation, things written down, photographed, so that you're not just relying on an officer's memory of the event, but they have a journal or a document that they can turn to and say, this on this date, this evidence was found in this location, so on and so forth. Finally, I mentioned the confessions, right? If the confessions were under duress, or the suspect wasn't, informed of his or her rights, then you can certainly call any confession into question. And unfortunately, we do see false confessions. The Central Park Five, for instance, those 5 young men were held and questioned for quite a while, hours and hours, without a legal representative, without a parent, without a lawyer. And so their confessions were invalid. They were false confessions, and later on the actual guilty party was identified, but those men had already been convicted and served lengthy prison terms. So it was largely built on the confession. Why would they confess if they hadn't done it? Well, sometimes people do confess because they don't understand what that confession means. They think that they're going to get to go home, they're going to get to see their parents, and they don't realize that you should never confess to something that's not true. All right, so looking at the admissibility of evidence. So we have Frye versus the United States back in 1923. And we see in our picture there's Dr. William M. Marsden, who was the proponent of his lie detecting machine, really tested blood pressure, and James Alfonso Frye. Together, it was actually Marsden who determined that his scientific lie detecting machine showed that Frye had not actually committed the murder that he had confessed to. This was Dr. Brown was shot and killed, and Frye confessed to this over a year later. and then said that the confession was really so that he could split the reward money with the detective. And it just was a messy case if you want the particulars of that case. But again, Marsden said that his machine indicated that Fry had not killed the physician, that it was a false confession, but the judge did not admit it. Because as we see in our right-hand side, expert testimony on a scientific technique is only admissible when that technique is accepted as reliable within the scientific community. And this new way of detecting lies by looking at blood pressure was not vetted through the scientific community yet, and was therefore not reliable method. And it's still today, the modern lie detector is not admissible for legal matters, and that's because it doesn't have the scientific validity we expect. There are people who can beat the lie detector, so to speak, and so therefore it's not a reliable method. If you want to learn more about Dr. Marsden, he was actually the creator of Wonder Woman. There was a movie about him a little while ago. So if you want to learn more about him, he's an interesting character. You can certainly go ahead and do that. But unfortunately for Mr. Fry, he was not allowed to present this lie detecting evidence that suggested he had falsely confessed, and he was convicted and served a lengthy prison sentence for that confessed involvement in the murder of Dr. Brown. Okay, so where the Fry criterion established that the scientific community should have broad acceptance of a method, and again, you're not going to get 100% of scientists behind it. Scientists argue by nature, and it's very tough to get a total agreement among a group of scientists, but at least a majority view in the scientific community that a particular method is valid. The Daubert case here, Daubert v. Merrill Dow Pharmaceuticals, it pushed the idea of really who gets to admit scientific testimony. And so in this decision, we had the federal rules of evidence took precedence over the Fry standard. The federal rules of evidence were established in 1975. So again, in the 70 years between the Fry criterion in the 1923 Fry v. U.S. case and the 1993 Daubert case, we did have those federal rules of evidence come up, and ultimately it was decided that the judge has the final say when admitting scientific testimony. So this case established the judge as the gatekeeper, and at least the places where federal rules of evidence take precedent. Again, the Fry standard is still the rule of law in a number of places, such as New York State, at least as of 2019, that's true. And so the particulars of the case, if you want to know more about Daubert, Daubert and a co-defendant were suffering from birth defects that they believed were linked to a drug that Merrill Dow had produced, and they had in vitro and animal studies to show that that drug caused birth defects. But the Merrill Dow was able to convince the judge that those methods, the animal studies and the in vitro studies, were not valid. They weren't scientifically accepted at the time, and they weren't human studies that would have been necessary to show that that particular drug caused those particular birth defects in humans. So again, the most important legal outcome for us today from the case is the judge is the gatekeeper. The judge determines when admitting scientific testimony in a legal proceeding. Now, just because the judge has the purview of that, at least in the states where the Fry criterion is no longer the rule of law, which in New York, at least as of 2019, the Fry criterion is still the rule of law, as in a number of other states like Pennsylvania and California. But in states where the judge is the gatekeeper, we have, again, not just the judge's whimsy to decide whether or not to admit scientific evidence, but really it should be determined based on a number of factors, such as can the theory or technique be tested? Is it a peer-reviewed theory or technique? What's the rate of error? Is it acceptable? Again, with anything in science or otherwise, there's some margin of error, and in our legal system, the U.S. criminal justice system, we're looking for guilty beyond a reasonable doubt in criminal matters. And so it doesn't mean absolutely guilty. It means guilty beyond a reasonable doubt. So again, if it's a reasonably low error, then that's beyond a reasonable doubt. If it's a large error, then that's not. Is the method widely accepted among the scientific community, or is it sort of a fringe thing like the blood pressure testing lie detector back in 1923? Is the opinion relevant to the issue? It has to be probative. It actually proves something, and it must be material. It actually has to relate to the crime at hand. And again, as said last slide, the Daubert v. Miranda, ultimately the judge will decide in those matters what's admissible and what is not admissible in court. Okay, so now let's discuss for a little bit the facets of guilt. So when trying to show that an individual is guilty, one must try to prove that he or she had the means, which means the actual ability to do the crime. So if we're looking at a stabbing, for instance, we would not expect that a quadriplegic, someone who can't move his or her arms or legs, would be physically capable. They would not have the means to commit that particular crime. The motive, again, did they have a reason to do the crime? This gets into the psychological aspect that we talked about with criminology. What was the motivation? You don't have to prove the motive, actually. It's the one of these three that you don't have to prove, but if you can't at least show some reasonable motive, you're not going to convince many juries that the suspect is a viable one. And finally, did they have the opportunity? Can they be placed at the crime, at the scene of the crime, at the time of the crime? Were they actually there? Were they physically present when that crime was being committed? So means, motive, and opportunity, the facets of guilt, again, really the underlying principles of how you identify the suspect responsible for a crime by fitting these three features. Looking at evidence admissibility, we have another legal proceeding. Again, we don't talk about a whole lot of legal cases in this course because we do try to focus on the physical evidence and the scientific underpinnings of that evidence. So if we talk about them, they're pretty important, and hopefully you have them down. So we had Fry v. United States, we had Daubert versus Miranda, and now we have Miranda v. Arizona, a 1963 case. So in this case, Ernesto Miranda was not advised of his right to remain silent or to an attorney. So the Supreme Court ruled in 1966 that statements could not be used as evidence since he was not advised of his rights when he made those statements. So this is another case where direct evidence, the statements that Miranda made, were not valid anymore because they were collected improperly. So again, an important case in evidence admissibility, and a case that the name Miranda is synonymous now with the Miranda warning that we'll look at in the next slide. Okay, and so here we have the Miranda rights, or the Miranda warning. If you've watched any crime drama since the Miranda case, you've probably heard the individuals acting in those crime dramas say the following: you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to speak to an attorney and to have an attorney present during any questioning. If you cannot afford a lawyer, one will be provided for you at the government's expense. So this Miranda warning, as it's often called, or Mirandizing a suspect, in this case, again, informing him or her of the Miranda rights, goes back to that case of Miranda v. Arizona, which involved the young man, 23 at the time, and Miranda was accused of raping a young woman. And so, again, there were some statements made during his initial interviews that he indicated that he was responsible for that crime, but then later on he was not advised of those rights, so those statements were not allowed to be used in the legal proceedings. So obviously it's become a landmark case, and still to this day you'll see the Miranda warning issued whenever an individual is advised of his or her rights. Now, within the purview of criminal law, all crimes are not equal. So let's take a look at some various types of crime. So the lowest level would be an infraction or violation, and that's a petty offense punishable by fines with no jail time. The fines, again, could vary, but in general, there's no jail time associated with an infraction or a violation level crime. Next up would be a misdemeanor, which is a criminal offense with up to a year of jail time associated. And it can include a fine as well, or probation, community service, restitution, something in addition to or instead of the jail time. Finally, a felony involves serious physical harm or threat, fraud, or other white-collar crime, and that would generally range from 1 year to life in prison. So obviously a much higher level crime than the other two, and therefore a much stiffer penalty. All right, so for the law fans, hopefully you've enjoyed this Unit 3. For those of us who are less comfortable with the law, we'll be back to the more science-heavy topics beyond this. But again, in conclusion, forensic scientists have to adhere to both scientific and legal ethical standards when gathering, examining, testing, and analyzing evidence, because their evidence is not only scientifically analyzed, but it's also used in legal proceedings, so they have to meet both standards. And we hit a few key cases. Again, you should know those 3 cases, the Fry versus the United States, the Daubert versus Merrill Dow Pharmaceuticals, and Miranda v. Arizona. Not so important to know the dates, but to know that each case had very far-reaching consequences, and to know those particulars of those 3 cases. So hopefully you've enjoyed this foray into law, and join me back again here for Unit 4, where we get back into the more science end of forensic science.